Uh, Perfect. Feel free to interact otherwise in the chat. If you want to talk to each other there, feel free to do that, but questions should go in the Q&A. We are recording today's session. It'll be available on slurk.info within the next few weeks. Closed captioning is enabled and available. If you don't see it on your screen, tap live transcript and tap show subtitle. Also, we're joined by Kara, our ASL interpreter. Thank you, Kara, for doing this for us. Now, I would like to introduce our guest host, Erin Kelly, the Enoch Pratt Free Libraries Accessibility Coordinator, to kick off our session. Hi, Erin.
Thank you, Tracy. Hello, everyone. I'm Erin Kelly. I'm the Accessibility Coordinator for the Pratt Library System, focusing on accessibility for our patrons, reasonable accommodations, compliance with ADA guidelines, training for staff, and a resource to our patrons, and more. I am also a resource to you, so if you have accessibility questions, feel free to reach out. And today I want to share a save the date for our spring 2025 State Library Resource Center conference, which will be focused on disability inclusion and accessibility in libraries in partnership with the Maryland Library for the Blind and Print Disabled. So a total focus on accessibility. Our virtual day is May 27th and our in-person day is May 28th, and we hope you can join us. Now let me introduce you to today's closing speaker. Amy Dreyer is a user interface developer for the University of Minnesota Libraries, co-chairs the Library Accessibility Alliance, and is active in several other accessibility groups. As a developer, Amy has redesigned and maintained websites from every aspect, including online catalogs, actively researching and applying digital accessibility for nearly a decade. Previously, she was a systems librarian for the U.S. Army and was involved in centralizing the library system, as well as led a web centralization project. And now I'll turn it over to you, Amy. Go ahead.
Great. Thank you so much, Erin. All right. I hope everyone can see that. Okay, so today I will be talking about ADA Title II and digital accessibility for libraries. As mentioned, I am Amy Dreyer, she, her pronouns, user interface developer for the University of Minnesota Libraries, and I notably co-chair the Library Accessibility Alliance. The Alliance is composed of 7 academic library consortia, including USMAI, the University System of Maryland and Affiliated Institutions Consortium. Thank you for having me here with you today. You can access these slides at z.umn.edu/sailor-2024. This presentation provides information about accessibility laws and regulations, but is not legal advice. You should consult a lawyer or your ADA coordinator for advice on specific legal issues or questions. Our agenda today includes key definitions to help better understand the space, ADA and its exceptions in the library context, digital accessibility for libraries, ADA for e-resources, and finally, some individual actions we can take. I'd like to start us off with a poem. This is called Now by Göran Sonevi, a Swedish poet. Now the chance opens to another way of life. Will we take it? Will we look it squarely in the eye? I believe the opening of the chance is very narrow. It shines at the threshold of a closed door which can be opened. It can only be opened by many people together. We'll begin with some definitions. Key concepts will cover our accessibility, web and digital accessibility, accommodation, disability, assistive technology, web content accessibility guidelines, or WCAG, and VPATs and ACRs. What is accessibility? Back to its root, accessibility is access to information, regardless of how a person gets it. This is the first core value of librarianship. We are using it specifically in the context of access to information for people with disabilities. For the definition of digital accessibility, we'll turn to the World Wide Web Consortium, or W3C, a group that develops international guidelines for the web. According to them, web accessibility means websites, tools, and technologies are designed and developed so that people with disabilities can use them. Digital accessibility encompasses the whole digital space. Accessibility isn't about checklists and adding extra features. It's about removing barriers. We also need to clarify that accessibility is not an accommodation. Accessibility is about making inclusive environments that are usable by default for people with disabilities. An accommodation is modifications for an individual on an as-needed basis that fills the gap between where an item that should already be accessible cannot meet a specific need for an individual, such as transforming an ebook into a specific audio format. What is disability? The list of federally recognized disabilities is long and broad. We have to take into consideration the intensity of the issues each condition may cause and how much it might affect any aspect of daily life. Often disabilities come in multiples, so each day may be different based on many factors. There's another big aspect to disability, and that's identity. It could be that someone has a disability but does not identify with it or as disabled. Stigmatism, work culture, peer pressure, the perception that you're less than. There's many reasons why a person may not internally consider themselves disabled, or internally do, but do not share it with others. So we have a legal definition for the purposes of the Americans with Disabilities Act, or ADA, which I think of as disability with a capital D, but disability lowercase d covers more. Disability is a spectrum from situational, like holding a baby or the sun's glaring on the screen, there's distractions, haven't had your coffee, to temporary, like a bandaged finger, medication side effects, reading glasses, or you have a headache, to permanent, such as hard of hearing, dyslexic, or you have memory loss. This quote from Alistair Duggins frames disability well, defining it as a mismatch in interaction between the features of a person's body and the features of the environment in which they live. Not everyone who has disabling experiences uses tools to help. As mentioned, someone may be experiencing this temporarily. They may have just come into the disability, or they don't want to or can use assistive technology. Here's some of the many available tech people might use online. Screen readers are primarily used by people who are visually impaired or blind. A screen reader can read content and interactions out loud. Screen magnification software primarily helps people with low vision, but can also help provide focus for autistic people or others that need support with focus. It gives them control over the size of text and graphics on the screen. Speech input software aims to help people with limited mobility who choose or need to vocalize interactions to a device. Switches, or motion or eye tracking. Switches are input devices with one or two large buttons that may be pressed with different body parts and is often used with X and Y coordinate scanning on the screen to make a click. A sip and puff switch is used to send signals to a device using air pressure by sipping or inhaling and puffing or exhaling on a straw, tube, or wand. And Braille keyboards are a type of keyboard featuring refreshable raised dots that is used by people with visual impairments to interact with the computer. The experience is similar to a screen reader, except sight is being replaced with touch rather than sound. The Web Content Accessibility Guidelines, or WCAG, first came out in 1999, and the newest version, 2.2, was published last year. WCAG is broken into 4 main principles, each with a set of criteria to meet. Perceivable for the person, that it's presentable in a way that they can discern regardless of which senses they do or do not have use of. Operable for the person to navigate, that the user interface and navigation components can be used by everyone, including people who do not navigate the web using a standard keyboard and mouse. Understandable to the person, that regardless of ability, people must understand not only the electronic information, but also how to navigate to find the information they want, and how to use any tools or features built into the website or interface. And robust, in that the content may be reliably accessed and interpreted by varied devices, including browsers and assistive technologies. Within each of those 4 principles are success criteria in 3 different levels of conformance, each building off the other. Level A is the absolute minimum. Level AA includes all of level A and is often recognized as the standard level of conformance. Then we have level AAA, which includes level A and AA and has some trickier success criteria to meet. For digital accessibility, we also have a basic measurement tool that was developed by the federal government. It's the Vendor Product Accessibility Template, or VPAT. In a VPAT, a product owner voluntarily identifies whether their product conforms to WCAG success criteria. A VPAT that has been filled out is also known as an Accessibility Conformance Report, or ACR. Please note, with ACRs, it's important to know who filled it out and on what parts of the product and what version. If a marketing team filled it out for a specific part of the product 3 years ago, only measuring to version 2.0 level AA, the chances of it being useful are very slim. If the company hires a well-respected third party to audit their current product version and all of its built-in functionality, that is far more likely to provide a more accurate risk assessment. So, always be skeptical when looking at these documents. Now that we have some foundational language, let's move into ADA Title II. What are the legal requirements for digital accessibility? So at the federal level, we have the Americans with Disability Act, or ADA, that was signed into legislation in 1990. A year later, the World Wide Web was open to the public, so the original ADA had no provision for physical versus online spaces. But 5 years later, in 1996, they made a statement that it did indeed extend to digital spaces. However, what that meant was unclear. Over this past decade, various legislation has made clarifications, such as in 2017, when Section 508 aligned with WCAG. The ADA did not identify a standard until this year. On April 24th, 2024, ADA Title II was revised with Subpart H, specifically for web and mobile accessibility. In this update, the Department of Justice lays out some very specific guidelines. ADA Title II applies to public institutions, including a lot of libraries and educational institutions. You can usually tell if your institution meets this requirement if they receive any public money. One of the specifics was a timeline. They provide 2 different deadlines based on the population of your constituency. For instance, if you are the University of Maryland, you are serving the state of Maryland, so the population of Maryland is the number you're looking for. With that, if you have more than 50,000 people, you have 2 years from its publication for compliance, or April 24th, 2026. If you service less than 50,000 people, you have 3 years, or April 26th, 2027. So what exactly are you supposed to have done by those dates? All digital content must meet WCAG version 2.1 level AA. You may be wondering what is included in the scope of digital content. It's simply put, anything that you are giving access to online. So WCAG version 2.1 level AA is the minimum any public institution should be aiming for. The revision also states it must be usable, which compliance to WCAG does not guarantee. The intent here is to ensure there's equitable opportunities for people with disabilities. So the federal government recognized there's a lot of online information, so much so that they wanted to help us prioritize what is important. Included in the revision are 5 exceptions. Before we get into those exceptions, also take into consideration state and local requirements. Maryland's digital accessibility policy is also set to WCAG version 2.1 level AA. You'll want to check whether it applies to your institution and if it changes your approach. And then you'll want to check your local institution's policy. While the federal regulation is set to version 2.1, your local institution may have a higher standard that you must meet, such as version 2.2. That said, if your local institution is set to a lower standard, such as version 2.0, you'll need to work towards the federal baseline of version 2.1. Okay, so the exceptions. We have 5, and they can be quite vague for libraries. They are archived web content, pre-existing conventional electronic documents, content posted by a third party, where the third party is not posting due to contractual, licensing, or other arrangements with a public entity, individualized documents that are password protected, and pre-existing social media posts, where pre-existing means content from before the compliance date, such as April 24th, 2026. Now, for each of these, there's accommodations and requests for effective access and communication that the institution already must abide by. Quote, the ADA requires that state and local governments have to provide individuals with disabilities with effective communication, reasonable modifications, and an equal opportunity to participate in or benefit from their services, programs, and activities. First exception is archived web content. Web content that meets all 4 of the following points would not need to meet the requirement. The content was created before the date you must comply, or reproduces paper documents, or the contents of other physical media, such as film negatives, that were created before you must comply. And the content is kept only for reference, research, or record keeping, and the content is kept in a special area for archived content, and the content has not been changed since it was archived. The biggest question here is whether digitized archival content might be considered archived web content. Here's a part from the archived web content definition. Fourth, the web content is organized and stored in a dedicated area or areas clearly identified as being archived. The definition is meant to capture historic web content that, while outdated or superfluous, is maintained unaltered in a dedicated archived area for reference, research, or record keeping. So the Federal Register provides a specific example for this. You can access it at the URL on this slide. In it, whether something's considered archived or not is likely dependent on whether it's been repackaged with something new, such as a digital exhibit or a course. The date that matters for this are the original document's publication date, as long as it hasn't been edited since, and scanning doesn't count, nor does turning that document into something accessible. So we might have the question of just taking it all down, which we have UC Berkeley to help with. In 2016, Berkeley was posting a lot of its educational materials online for the public. It was inaccessible, and the Department of Justice, or DOJ, declared it violated ADA Title II. Berkeley's response was to take it all down. The DOJ came back and decreed, nope, that was wrong, and Berkeley will now make all future online content accessible. Excuse me. So contact your ADA coordinator or general counsel to get their interpretation of whether what your library considers to be archival content is included in this exception. It is your institution that is taking on the risk of that interpretation. As these are new rules and exceptions, it will take time to define them as and see how things play out. Second exception is for pre-existing conventional electronic documents. Documents that meet both of the following points usually do not need to meet WCAG 2.1 level AA. Documents are word processing, presentation, PDF, or spreadsheet files, and they were available on the website or mobile app before the date the entity must comply with this rule. Situations where documents are currently being used to apply for, access, or participate in services, programs, or activities do not fall under the exception, even if the documents were posted before the compliance date. This is an important note. So you have documents that may fall in this category, but remember, this exception has that stipulation about being able to access or participate in services, programs, or activities. Older but active policy documents will need to be made accessible as they are currently used. What about digital repositories and articles? This is where your institution needs to decide how it interprets this and take on the risk of that interpretation. Then your institution will need to document the reasons for that interpretation. I have a feeling a lot of it might be in use for services, programs, or activities, though. Like with archived web content, it may be safer to consider that some conventional documents don't fall in the exception and to make a plan to improve accessibility where you can. The third exception is content posted by a third party, where the third party is not posting due to contractual licensing or other arrangements with a public entity. We get a lot of content from third parties, most of our e-resource content. In the majority of cases, they will not fall under this exception because we have contracts, licenses, or some form of agreement with them. You might think the content belongs under the pre-existing conventional electronic documents exception, but that has that clause again, that the documents are not currently being used to apply for, access, or participate in services, programs, or activities. So again, this is up to your institution to interpret, but I will drop in one more consideration. To address whether the library databases count, we have the Payen versus LACCD lawsuit, where LACCD stands for the Los Angeles Community College District. This was originally filed in 2019 when a blind student couldn't access materials to take their classes. The judge ordered LACCD to make the materials accessible, including removing barriers in the library databases. LACCD appealed, saying it wasn't intentional. The court rejected the argument. The fourth exception is for password-protected, individualized documents. Documents that meet all three of the following points do not need to meet the requirement. The documents are word processing, presentation, PDF, or spreadsheet files, and the documents are about a specific person, property, or account, and the documents are password protected or otherwise secured. Related to library land, we have digital interlibrary loan. So this service is usually based on scanning in physical content to electronically deliver to another institution per request of an individual we serve. It's often accessed by some type of security. But is this about a person, property, or account? My personal opinion is not really, but your institution may interpret that differently. Again, document your reasons, but also if you have this service, it may be worth implementing an optical character recognition or OCR process as a first step towards making the documents minimally better. And the fifth exception is pre-existing social media posts. For many public entities, making all their past social media posts accessible may be impossible. There also may be very little use to making these old posts accessible because they were usually intended to provide updates about things happening at the time they were posted in the past. For these reasons, social media posts made before the date you must comply do not need to meet the requirement. All posts afterwards do. Fundamental alteration or undue burden exceptions already exist. This may seem like an easy out since libraries have complex relationships with content and providers. This, however, needs to be considered as a last resort. Here's the language. Where a public entity can demonstrate that compliance with the requirements would result in a fundamental alteration in the nature of a service, program, or activity, or an undue financial and administrative burdens, compliance is required to the extent that it does not result in a fundamental alteration or undue burdens. Public entity has the burden of proving that compliance would result in such alteration or burdens. The decision must be made by the head of a public entity or their designee after considering all resources available and must be accompanied by a written statement of the reasons for reaching that conclusion. And the public entity shall take any other action that would not result in such an alteration or such burdens, but would nevertheless ensure that individuals with disabilities receive the benefits or services provided to the maximum extent possible. So even if something is approved as a fundamental alteration or undue burden, you still need to find a way to improve accessibility. Okay, that was a lot about the new ADA Title II and all its baggage. So let's look at library content and how to frame digital accessibility in our space. We'll begin by identifying 4 types of library content and related skills for meeting digital accessibility. The first type of content is vendor or subscription-based content. This includes databases and third-party content like ProQuest and Overdrive, purchase tools like citation managers, mobile applications and other software, and platforms such as for publishing. Because we don't directly own this content, the types of skills we need here are negotiation, communication, testing and auditing, and advocacy. This one we'll get into more later. The second type is content for public consumption that we control or steward. This type includes digitized archival content, repositories we host and have authors submit content into, instructional content such as tutorials and guides, and websites. Here's where we need to build skills in development, design, and content accessibility. Folks need to know the core accessibility skills and how to apply them to content, but also to additional formats, including PDF, so they may review the files and know what to look for. For those who work more closely with the interface, they need to know WCAG and how to properly implement and test for it. And because this does require remediation of old and new content and developing policies and workflows, project management skills are necessary. The third type is virtual services. This is a separate category because library employees often have a more involved role than the first type. This would include services such as online chat, virtual reference or consultations, and digital interlibrary loan. For skills, we need content and document accessibility for multiple formats and using accessible communication techniques. And the fourth type is internal content. Just as our patrons may be disabled, so too can employees. But this does extend to patrons as well, as it covers workflows, processes, and documents. And often workflows, processes, and documents directly and indirectly impact everyone. For skills, it's again about document accessibility, making sure we're using captioning and inclusive meeting practices, and requiring digital accessibility training. Whether Title II may or may not apply to your internal content, according to your institution's interpretation, ADA Title I does. Title I refers to Section 508, and if you recall, Section 508 refers to WCAG version 2.0, level AA. So either way, it should be considered. Here's a possible library action plan. You may do this completely differently. Make sure you are communicating and keeping folks abreast of decisions. It may work best to establish a team to take this on. So first, you should understand what your institution's obligations are and what's your deadline. If you have a team, they should likely have someone with legal expertise to help interpret the regulation, but also they need to review what the guidelines are. Then inventory what you have. Once you know what you have, you can figure out how to perform accessibility audits to determine how much work exists. You'll want to determine what of your inventory meets the exceptions and document the reasons thoroughly. Remember, the goal is for it to stand up in court. Once you have all this information, you can begin prioritizing and developing your roadmap. This is also incredibly important documentation because the likelihood of any of us reaching compliance by the deadline is very slim. I would say zero. There's a 0% chance any of us get there. We'll need to be able to prove we're making progress. At Minnesota, our Office for Digital Accessibility has been developing a workflow suggestion. Remove old and outdated content, revise and replace content we need, and write first means make it accessible from the beginning. These happen around the core digital accessibility skills. Share your library expertise with and establish internal partners, such as with an IT department. I've been in a lot of meetings with various people, and I have to say, if you aren't working in a library, you just don't get it. And train people. Embed accessibility throughout all the processes, monitor progress, and maintain it. We're going to look now specifically at 7 actions for digital accessibility in e-resources. The first step in our collections is to commit to accessibility work. Writing it into policies solidifies a commitment. At my institution, we have posted our collections values online. In the second value, open and enduring access to information, we have a section about accessibility. The libraries expects content and hosting platforms to be accessible to all our users as required by law. The libraries prioritizes working with vendors that meet expectations for equitable service and access as outlined by the BTAA Library e-Resource Accessibility Standardized License Language. It's a very long name. Publishers who have not yet met these expectations need to show progress toward doing so, and when requested, adapt licensed materials to comply with applicable law in a timely manner and at no cost to the libraries. So, all e-resource contracts need accessibility clauses. As mentioned in the previous slide, the BTAA has a few versions of recommended language to use in vendor contracts. It hasn't been reviewed in light of the ADA Title II revision yet, but it's still a great template. For their US language, they have licensors shall comply with the Americans with Disabilities Act, ADA, by supporting assistive software or devices such as large print interfaces, text-to-speech output, voice-activated input, refreshable braille displays, and alternate keyboard or pointer interfaces in a manner consistent with WCAG 2.1 AA. Licensors shall ensure the that product maintenance and upgrades are implemented in a manner that does not compromise product accessibility. Licensors shall provide to licensee a current, accurate, completed VPAT to demonstrate compliance with accessibility standards. Some universities are also pursuing indemnification clauses, which would transfer the financial risk of inaccessible content back onto the vendor. Some institutions may not allow this approach. It's something folks may want to dig into. The Library Accessibility Alliance worked on a Dear Colleague letter over the summer. This was modeled on a jointly written letter from the Department of Justice and Department of Education for higher education back in May of 2023, emphasizing the need for accessibility in education settings. The LAA's intent with its letter is to raise awareness with library vendors of the revised ADA as a primer for conversations. At the beginning of this month, the LAA's vendor relations team sent it out to over 100 vendors with more planned. In it, we request vendors consider the following: set goals to meet WCAG 2.1 AA, ensure all content complies with accessibility standards, prioritize born accessible content, include accessibility-related language in contracts, provide a dedicated accessibility contact, include public accessibility statements, and publish accurate ACRs and accessibility remediation roadmaps. While this hopefully helps to prepare vendors for the conversation, it's up to each library to establish contracts with an accessibility clause. Ask for documentation. What LAA is requesting in that letter is the information you need to be asking for, specifically their goals for meeting your legal requirements, preferably as part of an accessibility statement, what content they have complies with standards or how they address content that doesn't, their accessibility person or team and how to contact them, accurate and up-to-date ACRs and remediation roadmaps and accessibility language in the contract. Know the requirements. There's simply not enough time to do this in one session, so we'll do the short version. Video requires captions and audio descriptions. Audio requires transcriptions. Images require good contrast and meaningful alternate text. Documents require good contrast and semantic content, like a heading is made with a heading and not simply styled to look like one. And websites need all of the above and good navigation. There's a lot to learn here. I have 3 resources that you can check out. There's the Understanding Docs, the great article, WCAG 2.1 in the current state of web accessibility in libraries. And then there's an online course that you can also take for free. Audit and test. For this, there's a couple approaches you can take. Auditing is determining what accessibility issues exist. The first approach is to outsource the testing of each e-resource. This could be a reputable third-party consultant, which would be expensive, or perhaps you can partner with an IT or disability services department. A more sustainable approach is to train internal staff. Remember, accessibility is a legal requirement, so verifying the risk isn't really outside the scope of an e-resource support role. To do this, you need a combination of both automated tools and manual testing. The Web Accessibility Initiative has an easy checks page to help you get started. For automated testing, you can install browser extensions to test individual pages. Some more well-known extensions include Wave, SiteImprove, etc. I often use a combination of these. Also, you can check if the LAA has done its high-level testing on the e-resource. Vendors have an opportunity to respond to that test. They are performed with reputable third-party accessibility consultants and can give you a starting point with your audit. Since we have this legal obligation to document everything, including the progress we make towards accessibility, plan to include that in your processes. Document your findings internally so you can refer back to them later to prove you've made best efforts to move accessibility forward. Report your findings to the vendor, track their responses in response time, report any accessibility errors found by other staff or patrons and document that, and remember to communicate progress on errors to staff and patrons to increase transparency. For many e-resources, There may be no alternative to inaccessible content. However, some libraries are at a point where they are beginning to walk away from vendors who have been uncooperative. This is the last step, when the library has realized this vendor is not going to be supportive of our legal requirements. You'll know by their response to all the steps we've already covered. This is the only way we've been given by the federal government to do any enforcement. Here's a recap of those 7 e-resource actions. Sorry, just leave that there for a second. And then for library employees who do not directly support e-resources, you have some responsibilities here as well. So keep an eye for anything that may not be accessible as you use a resource, and know how to report an accessibility bug or error at your institution. Okay, continuing with what individuals can be doing, let's look at more individual actions. The 7 core accessibility skills are from the University of Minnesota's Accessible U website. Again, the short version. Alternative text, in which we describe graphics like we are describing them over the phone to someone. Contrast, in which the text color contrasts enough with the background color to be easily read. Headings, in which we chunk content into with meaningful labels that are set with semantic headings and not just by style. Links, in which the text we link to is meaningful. No click here or read more, but rather read the return policy or read more about the visiting author. Lists, in which we use semantic bullets or numbers to break up sentences or content, not only by styling. Tables, in which they are used only to display data, kept simple with well-labeled headers. And video and audio, in which they are captioned, have audio description that describes the actions in the video, and if audio only, they have transcripts. You can learn how to implement each of these skills by visiting accessibility.umn.edu or check your local institution's training offerings. What now? This was a lot. And I'm sure there's also a lot of questions. You may disagree with me. This may present itself differently at your library, but I do hope it was helpful to frame it within our weird space of content stewardship. My suggestions for next steps are to bring this back to your library and ask questions. It's been amazing how many people just don't know. Step up and into the work. Some of it is yours. And if you aren't feeling the support you need, put it in a performance plan or something more official. Build your confidence. It's easy to feel overwhelmed, and what you can do is just break it down and do what you can today. It's honestly never a good idea to eat the whole cake in one sitting. Cut a slice, savor it, and anticipate the next piece to come. Learn from the mistakes. They will happen. I still make plenty myself and continue to learn. And encourage and support those around you. It's sometimes easier to grow together and know others are learning just like you are. We are all at different stages of our journey. And I'd like to wrap up with a quote. Do the best you can until you know better. Then when you know better, do better. Thank you. With that, I'm just sharing a few more resources here. If you remember, I gave you the link to the slide, so you can access all of these links through that, and that's z.umn.edu/sailor-2024. But these are also really great tools to use in this process. All right. That's it for that. Does anyone have any questions?
A reminder to everyone, if you have questions, please add them in the Q&A. If you can't find the Q&A, I will also keep an eye on the chat.
Thank you, Amy. I'll give everyone, yeah, a ton of information. That's exactly what I was thinking. I wrote down a ton of questions, but I feel like they're all for me. And maybe, you know what, I honestly, like, I'm afraid to ask them because should I already know the answer to these questions? You said something about, gosh, when you're sending someone a link, don't use the link is here. And I
Right.
think I know what you mean. Can you repeat that again? Because
Yeah. So with links, I see this all the time. People will like arbitrarily write the sentence to add the words click here, instead of using the text that's meaningful, to be the link. And the problem with this is when you're coming at this with assistive technology, you can pull up, like with a screen reader, a list of all of your links on the page. And guess what? All you see is click here, click here, click here. And you have no context, no idea what these links are. It's a similar issue with voice activated technology, because if you've got like 6 click here's, it's going to be a little bit of work to figure out which link you're pointing at or you're meaning to click.
thank you. We have time for more questions. I see lots of comments. How about you, Erin? Well,
I know it's a lot of
yeah,
information. So again, that's why the slides are available. You can go back and take a look at it, take a look at the links that are in the slides. All my words are there. That is an accessibility feature that I include in my presentations. So you can revisit all of this, especially when you sit down to think about your area, what you're doing, and how it might apply.
great. All right, you're getting lots of thank yous in the chat. Um, thank you so much. Erin, do you want to say anything else before we wrap it up?
Thank you again for all of this information. I think this is really helpful to us as we evaluate the law and kind of what do we need to do from here as a starting point. So appreciated.
All right. So Amy and the conference team, Erin, Michael, Danielle, who's behind the scenes, managing all the technical stuff here, Paula, who's out in the hallway, taking a break on this one. Thank you all so much. It's been a great day. We have learned a lot. Thank you, Amy, for taking the time. I cannot wait to check out all the links that you sent us in your presentation. And thank you for sharing the entire presentation. That presentation and this webinar will be posted to slurk.info within the next week or so. So anyone who needs to find it in the future can look there. Attendees, remember to look out for CEU forms and evaluation forms. Tomorrow is our in-person conference. So MPearls, e-resource librarians in Maryland will be coming to the Pratt. Oh, well, maybe all this information that you gave us, Amy, will help us when we're talking to the vendors tomorrow. We can see,
Exactly.
yes, who cares and who knows about all these regulations. So we look forward to those of you who can come here tomorrow. And thank you all for joining us today. We hope you enjoyed it and take care. All right, bye.